procedure would normally be we would abate the immediate hazard and or bring the building down. And then that same contractor would be retained to take that debris to a landfill and make all the necessary disconnects with city services, remove the foundation, and restore the lot to a level condition.
And is that a contractor that's retained by the city, and then is that cost then charged back to the homeowner through property assessment or something?
Yeah, that would be assessed back to the homeowner, okay, to the property owner, yes.
Okay, but the work remains under the purview of your department until it's restored to a level site?
Yes, that would be standard procedure.
But the remaining debris is the property of the property owner, or is it at this point in the control of the city staff? Does that make sense?
Yeah.
Henry Reimer again, formerly of the city attorney's office. The debris that's on the site is the property of the property owner. And so if there are any items of value that are remaining in the debris, the property owner has the right to salvage those and retain those. If the property owner doesn't do anything with what's on the site, and that's typically the case for us, we abate the nuisance. So everything, and particularly for an emergency demolition, everything is considered hazardous materials because there is a very strong likelihood that amongst that debris we're going to find asbestos, lead, other types of materials that will not go into a standard landfill. So it's all hazardous material and it's disposed of as such. And it's probably not likely, but there's a possibility that there may be some features of historic significance that could be preserved or salvaged from the debris. I think at this point we probably need the property owner's cooperation in salvaging those since it is his property. We have not taken his personal property. What we have done is abated a public safety nuisance.
Okay. And then, so once that work is complete, your work is done, and it's the property owner, they can do with it as the regulations, zoning regulations, etc. allow.
Correct. We do not take possession or ownership over the property when we engage in a demolition. So the property continues to be owned by the owner, but now it's subject to the assessment of the cost of the demolition. So that is something that the owner would have to pay to retain ownership.
Okay, Commissioner Anderson, next question.
So what happens on Monday? Do you have to have his permission to remove the debris, or can the city on Monday?
As things stand right now, the arrangement with the contractor is to remove the debris on Monday. Since it's fenced off and that reduces the hazardous situation of having a pile of debris in a lot, if we are on the track for a plan, if somebody can identify that there are items worthy of being salvaged, and then there's a plan to salvage them, we can delay that debris removal for a short period of time. But imagine living next to a pile of rubble like this, and the neighbors aren't going to tolerate it for too long, and they shouldn't have to. So.
But the time is very short.
Yes.
For something to happen.
Well, we are not going to require a complete plan in order to hold off the removal of the debris on Monday. But we have to at least see some light at the end of the tunnel. We have to see that there is some value in delaying the removal of the debris. And if there is a plan that's being put together, we will hold off the removal of that debris so long as we are confident we have some control over the site and it's not creating a hazardous situation. And that's really our goal. I think over the next several days we're going to be working very hard with the preservation and design folks to identify if there is something that is worthy of being saved and if there can be a plan to salvage any of those things. So really we have a few days to see if there is anything that can be done, and if we make an initial determination that we could do something here, then we'll hold off the debris removal. If we make an assessment that the demolition has destroyed anything of value, then there really is no purpose in holding off the removal. So we'll have to make that determination early, but we don't have to have the full-fledged plan nailed down before Monday.
What is your definition of short period of time? Not to try to.
I would say within a couple of weeks.
Okay, great. Commissioner Morris has a question for you.
Yes, you've addressed the question of salvage very clearly. The term mitigation, which is most commonly found in Section 106 reviews when property must be removed and a plan put in place to mitigate that loss. Is there a possibility of mitigation, or perhaps is this a question better suited for staff?
Probably better suited for staff. Probably better suited for staff, I think.
Yeah, well, probably it is, Mr. Chair, Commissioner Morse-Kahn. But from my perspective, I think at this point, the extent of mitigation would be if there is a chance of digging through the rubble and finding some things that can be salvaged, then that would be the mitigation. I don't know that there's much additional mitigation that could be done. The preservation and design staff are much more familiar with mitigation than I am, but when I'm talking about salvage, at least in my mind, we're looking at what we can do to maximize mitigation in terms of identifying anything that can be saved from what's left.
Thank you.
Yeah, I think there's certainly a distinct difference between salvage and mitigation, and your role in terms of salvage is
Sure.
Sounds correct, but in terms of mitigation, there's lots of other things that aren't necessarily physical or actual building,
Yes.
building material related.
Yeah. Understood.
That we can explore. Okay, are there other questions of these five gentlemen before we let them go? Okay. All right. Thank you very much, both of you. Thank you for your time. Okay.